everybody. I am Francois Ballestro. I represent the European Transport Workers Federation, which is a federation which has 250,000 civil aviation employees as members. So I'm dealing with civil aviation, and my presentation will be directly I think, completing the one of Jack, because Jack, you mentioned various topics that I will touch. I will not go into too much details because you gave a very good explanation. But when I was preparing my presentation yesterday, I told myself, how can I make the participants aware about the problems that we face to tackle the social dumping? And I said, I think it's good that I show you the current EU legislation that it exists in civil aviation. And from there, we will see what is the reality today. I will not go too much into detail because Jack already presented some issues on this. And after that, I said to myself, okay, I think it's good that if I show you the loopholes and what are the next fight for the future. Because as you know very well in your country, when we try to fight against the social dumping, the collective agreements are fundamental, but it's not enough. You need also a law. And my point, it will be more to work and to show you about the legislative process, taking into account that at company level, an important work must be done. And I would like to use this moment to thank LO for the invitation and for the very kind welcome that you did. Thank you very much. And I see that we have some civil aviation colleagues present from different countries here. I'm very happy about that. So I will show you, as I told you, the existing European legislation, and you will see from there how some companies tries to go avoiding this legislation, but without being out of the European right. So it is very important, this issue. And I will concentrate mainly on the airline industry, because there is also social dumping in ground handling, and it's coming as well in the air traffic management. But here I concentrate only on the airlines. And you see here the first legislation we have today. It comes from the liberalization of the civil aviation in Europe, which began in the early 90s. But they revised it, what we call the third package. And together with the European Cockpit Association, in 2007, we fought in order to have, inside of the legislation, we have a protection of the workers and saying that the member state should apply the national legislation in the country where home base is located. Unfortunately, we did not succeed. This what you see here, it's a recital inside of the legislation. And you see, the wording is very important at European level everywhere, but you see that it is should. It's a recital and it is should. It means that they don't have to do it. And this we lost this battle. And from there, after that, we did not work on this issue directly anymore, but we try to push to have to work on other legislation. And then it is what we call Rome 1, the convention. It became a regulation also in 2008. And this is governing the type of contract they can have in the civil aviation. And this is the case with Ryanair, for instance. So the employment contract shall be governed by the law chosen by the parties. In case of no choice, the employment contract shall be governed by the law of the country in which the employee habitually carries out his work. So you are an employee, you go to have a contract with Ryanair, for instance. They told you the law is Ireland. That's it. But I don't want. Okay, so but I don't employ you. So, and this is the issue is this one. So with this, we still have a possibility of negotiating if you have a fair employer in front of you. But we are confronted with the cowboy companies today. And this is why this legislation can help, but does not help too much at the end. So then you have, in 2009, we succeeded, and it's a big success of European Cockpit Association, Association of European Airlines, the employers, and the ETF. We succeeded to obtain something for the social security. It is very important because now we will have the possibility to have the home-based principle that will apply on social security. But there are two problems with this, is that one, the transitional period is 10 years, so it's not yet applied, okay? Because you see, 2009, when it becomes in the different countries, normally it's 18 months, 2 years, and then you have a transitional period of 10 years. So this will not be applicable before 2020, and maybe a little bit more. And the problem we have here is that when you have a multiple basis, not only one, then the member states shall determines which social security system must be applicable. So it's still a system which is unstable. And the fourth legislation is the one of this year, the flight time limitations, together with ECM, European Agency Safety Agency, Civil Aviation Safety Agency, that had also different means to accompany this legislation. But for the first time, you will have an harmonization of the flight time limitation at European level for aircrew. And this legislation will come into force in 2016. So this is what we have at EU level. You can imagine this with these four legislations, with two of them are not yet implemented, and the weakness of the others. You can see that the companies have a large margin of maneuver. Then I said, okay, what does it exist at national level? I took two examples. But the first one is fundamental. And I diverged a little bit with Jacques, is that we need to have an action at European level, but we can also have an action at national level. The French did it. They did what they call a social decree in France in 2006. When we reviewed in the time, when we reviewed the first one, regulation, what we tried, it was in 2007, we have tried, ici and us, to put the French social decree into the European legislation, this one. And what does it say, this decree? Very simple. When you have a home base in France, the company must apply the French labor code. It means the labor legislation must be applicable. And you will see that it's very important because there are two articles in this decree. The first one is this one. So very simple. And with this, the French workers are protected with the lawfare airlines. If France did it, other countries can do it as well before we have it at European level because it's so long. So now we are encouraging the colleagues to fight in their country to try to have a social decree like this. Why we forgot it? Because in 2007, when we lost the battle, it came directly FTL. And we were mobilized for years about FTL. But now is the time to come with this issue again. And in Belgium, just an example, I think that other countries, other countries also have different regulation, but they also develop legislation on Bocuse self-employment in 2012, where they give 8 guarantees and protections to the person executing this kind of work. So just to say, we need it at European level, but national countries, national member states can take legislation. And this is very important because if you don't do this at the same time, let's say my thought is the following: is if we can succeed in the social decree in 2, 3, 4 countries, then we will have more power at European level to move it. Because when we try to have it in Europe, we could make some progress in the Parliament, but after that the Council cut it. So this is... Then let's say rather quickly, because Jacques already explained it a little bit, but what is the reality today? With some companies, I put with some companies on purpose, because we cannot put all of them in the same box. It's not true. We have airlines who are tough, difficult, but we can negotiate, we can discuss with them and so on. With others, it's more, some of them are more difficult. So there are new employment models developing. It was already explained. So for the flight crew, bogus self-employment, based in foreign countries, EU and non-EU. I will come back a little bit on this later on. And also pay to fly, we saw in the demonstration of Jack before. And the cabin crew, you have more and more agency work, temporary agency, and seasonal work and precariousness, which is developing. In precariousness, you have different forms of contract which are developed, and externalization of the contract. Then I took 2 cases, Ryanair and, of course, Norwegian. So in Ryanair, as you know, certainly, but it was touched by Jacques, but there are, let's say, some research showing that there are 220 self-employed pilots working for Ryanair in Ireland. And as you know, Ryanair, we have different court cases with Ryanair. I put it some of them, but you have also in Italy, you have also in Spain. But Charleroi, Belgium, 5 cabin crew claiming 20,000 euro each, contract dismissals. So CrewLink is a temporary agency working for Ryanair, is condemned, CrewLink go to appeal. So what's happened there? First judgment, and you will see in different places, is more or less the same. First judgment, there is maybe a difference in Norwegian court case. So you win in the first court, labor court, then they go to an appeal and they win. Because Chicago Convention. Chicago Convention said that when you are inside of a plane, you are depending of the legislation of the plane where it is registered. And there is no European legislation compensating this. But in France, no. Ruling in Aix-en-Provence, 2013, pilot and cabin crew unions and individuals, breach of social decree, they went then about social decree, Ryanair lost. And they say they will appeal. But here, they have I'm waiting for this judgment. In principle, Ryanair must lose in appeal here because they have a national legislation protecting them. It will be very interesting to follow this case and to see if the social decree in France will be really effective. And it is an important ruling, this one. And here in Norway, you know very well the case. An Italian cabin crew was dismissed. The cabin crew lost and went to appeal. Ruling of Broadcasting Court of Appeal in August 2013. Ryanair to pay, Ryanair appeal. Ruling of the Court of Appeal of Broadcasting in March 2014, 2 weeks ago. The cabin crew won the case and she's awarded legal cost, but the question of the law applicable is still pending. So we still don't know if it will be a Norwegian law or the Irish law will be. So you see that it is a very interesting cases this. Because it is where, imagine that they say, Norwegian law, oh, it's a big victory. Huh? Did not happen yet. Huh? In Italy, the judgment, also cabin crew, it say, we don't know which law must be applicable. And in Spain, the same issue. So it's a kind of a judgment neutral. Here in Norway, it's interesting because in appeal, the cabin crew won. This is the first time that in appeal we won. Because in Belgium, we had various cases in the past that I followed carefully at that time. In appeal, we always lost. So we have to have a view on this. So the specific case of Norwegian, so Jacques explained the mechanic complicated that they developed. And so they had, because now the issue of Norwegian is also because we have an open sky agreement between EU and USA, and they want to do now long haul from Europe to two bases or three bases in the US. This will not help us as well, the open sky, because we can speak about this as well. But there are internationally, there are no European international body who can make binding laws. In Europe, we have the European Union, and with the EFTA agreements, okay, you are directly going inside as Norwegian people. So directly, there is an agreement, but at global level, there is nothing. And there with the ECA, we are also doing an important work, and more than us, by the way, on this issue, but we participate also in an important way in this process some years ago. So they have, okay, Jacques explained this, and the island AOC, so they have traffic rights to and from the EU and to employ flight cabin crew on foreign contract. So Singapore and Thailand, you can imagine. And we are really saying, but how can we defend the workers in this case? Because the problem is not so much Norwegian. It is that this model can be developed by others. And you can imagine that if we don't have a minimum of protection, but our sector will be throughout, because we will not be able to have a standard life, a good standard life, without saying all the problem of oversight, of safety, and all the issues. So where are the loopholes? I made this this analysis with my colleague in the office to say, okay, but what is missing here? So we have a single European market, but there is no uniform social legislation. And there is a lack of EU social legislation. This is obvious, and you Confederation, LO, and so on, they know very well because I work in the ETUC, and when we claim a social Europe, it concerns all sectors, but and all sectors each sector is concerned, and we are concerned. So social legislation, if existing, is not aligned with the technical legislation. For instance, the link between the home base and the social security benefits and the labor laws. There is no link there. This is a big issue for us. They liberalize, but after that they don't compensate on the need we have. So it was mentioned also earlier, the different taxes and social security system in the EU member state, which is good. We cannot have uniformity, it's not that. But the fact is that it's not clear, the situation. The situation is not clear. We are fighting for the social security to have a good coordination and to have a good understanding, and we don't have it. So we need to keep our social security model and so on. It's not that we need to have one. No, but we need to coordinate this in such a way that the cabin crew, the pilot, know where they have to pay the social security and so on. Because it's complicated. We are in a sector which is moving, and people don't stay for once in a place. And open skies are creating additional problems. It's important for the traffic, for the growth, and so on. But we need to have also a minimum of framework of this. And this is a long, because we negotiated, as a European, we negotiated together with the States, with the Canada. We are finalizing now with Brazil, and other contacts are taken with Asia. So this is growing, and you will hear more and more. And Norway, let's say Norway asked to join the EU-US agreement, and they joined. That's why Norwegian went there. And when Norwegian made an application in the States, we had a lot of letters attacking the model by us, but not only us, the workers, but also airlines. Lufthansa, Air France, SAS made letters saying this is not what we want. We have to protect the model. So we have a kind of alliance with the regular carriers, and I think it's important to have this strategy as well. So what are the alternatives we see? So we have six issues. So first of all, Jacques mentioned this, it's a recognition of the trade unions and the capacity to negotiate, to have collective agreements. This is fundamental because it's not easy to have it everywhere. So we push as well for adoption of national social decree. I think it is very important, as in France. But also we need to have a kind of model like this at European level on labor legislation of country of home base applies. Revision of the regulation on common rules for the operation of air services to make binding the application of the national social legislation. You remember the legislation of 2008. Adoption of an EU legislation on self-bogus employment. Today, nothing exists, but yesterday, or 2 days ago, in the Parliament, they are working on a posting directive, which concerns mainly building sector, and the wood and building sector. And in this posting directive, the Committee of Transport put something for the first time about a definition of a worker. What is a worker? And on this, they refer to the self-bogus employment. So for the first time, we will have, if it's confirmed by the plenary of the Parliament and by the Council, but as it is a dialogue that there was between the Commission, the Parliament, and the Council, we think that we are in the right way. So it is something is beginning, but we have to push for something larger. And there is a legislation on temporary agency directive. There is a directive on this, but we need to improve it and to adapt it to our problems, because it's not adapted to our problems. This directive was equal treatment, but they can't circumvent it. We need to have more protection. And to improve also the social security coordination. We did not succeed on this. We tried to have, because there is an instance working on this, we push for it to review, to shortening the 10 years transitional period, and to clarify in case of multi-basis. We did not succeed yet, but there was a misunderstanding between some countries supporting it, others, and also a kind of a procedure problem. We will come again on this issue. But this is an issue that we are working, airlines, Association of European Airlines, ECA, and ETF together. So it's important that you see that the social dialogue are also an important tool for us, especially on this kind of issues. Thank you very much.